second lead on Urban Debate this evening. Imagine two parties being in a broken marriage, in a situation where reconciliation is not even remotely on the table. The couple has been living separately for years, but has to still wait out the cool-off period mandated by family courts before they can get a divorce. This pain and agony of thousands of people was soothed today by the country's top court, which is the Supreme Court, which ruled that it can directly grant a divorce in such cases. What this means is that exercising its special powers under Article 142, petitioners can be granted divorce without having to wait for the cool-off period, which is typically between 6 months to 18 months. This is mandated by family courts. Now, the same process was ridiculously slow until now. Both the parties had to file for dissolution of marriage, and then began the long waiting period, which was a minimum of 6 months and could go on for as many as 2 years. Now, I'll come to Article 142 in a bit, but you need to first understand what an irretrievable breakdown of a marriage is according to the Supreme Court. Because the Supreme Court is saying we are only interfering when we know that the marriage is beyond salvation. The court has said that when a marriage is completely unworkable, emotionally dead, it is totally broken and is beyond the scope of salvation, it amounts to a case of irretrievable breakdown of a marriage. In fact, the court even said that it is cruel for both the parties to stay in a marriage that is completely broken down. Now, this fast-track divorce will be possible with the Supreme Court exercising its powers under Article 142, which allows discretionary powers to the Supreme Court. And using this, the apex court can pass an order that it deems necessary for delivering complete justice. And here's the important bit, the court can also use its powers under Article 142 and dissolve a marriage, even in a case where one of the parties does not agree to that divorce. But it's not as easy as it looks. The divorce petition will be first transferred from a lower court like the district court or the family court. It will have to be transferred to the Supreme Court. The petition will then be filtered using factors like period of cohabitation after marriage, when the parties last lived together, nature of allegations being made against each other, and the number of mediation attempts that have been made. It's only after the court is satisfied will it even take up the case. India's top divorce lawyer is joining us here on Urban Debate this evening. But before I go to her, let's quickly take a look at the numbers when it comes to divorces. Although divorce rates in our country are on a steady incline, we'll put the pictures and numbers out for you. India currently has the lowest divorce rates in the world. Maldives actually tops the charts. The global divorce rates, just by the way, are up over 250% from 1960. Mrunalini Desmukh is a family lawyer. She's joining us from Mumbai. Thank you very much, Ms. Desmukh, for joining us. Rekha Agarwal is a lawyer. She joins us from Delhi. Thank you both for joining us. Ms. Desmukh, can I start with you and ask you this? Many people I've spoken to since morning are saying this is a landmark judgment. Can you help our viewers understand why you think this is a landmark judgment?
So at the outset, it is indeed a landmark judgment. And to understand this, we need to see what has been happening in courts, how clients and litigants have been languishing in courts. And for that, I need to just explain one thing. In India, under the Indian legislation, or the marriage laws as we call it, there is either a mutual consent divorce, where both the parties are agreeable for a divorce on certain terms and conditions, which is typically laid down, or there is what is known as a fault ground of divorce. Then you have to prove that the other spouse has been guilty of cruelty, adultery, desertion, etc., the grounds which have been laid down. Now, there is no ground where parties are separated over a long period of time and there is no chance of a reconciliation, no other issues exist, but because one of the parties is not agreeable for a divorce, for whatever the reasons, maybe rightly or wrongly, the other person who seeks divorce has to languish in courts. I have cases which I've dealt with, which have gone to 12 to 13 years from lower court to high court to the Supreme Court, and at the end of it, in a couple of cases, the Supreme Court has also said, sorry, there is no cruelty made out, there is no desertion which has been made out. It's very sad that you all have been away for the last 18 years, 20 years, but you have not fulfilled any of the grounds which come under that. What does a person do under such circumstances? Stay married? And married for what? Does it really make any sense? I think with these number of cases that have come up before the court, that is where the courts have realized that even if one of the parties are disagreeable when the matters reach the Supreme Court, even if one of the parties decline to agree for a divorce, and all these factors are there, there's a long term of separation, litigation going on for several years, the parties can't see eye to eye. This is where the Supreme Court, under this new landmark judgment, and that is why I think it's exceedingly heartening. It is exceedingly landmark, and this is really going to give relief to a lot of people. We are not propagating divorce, but those who feel the pain and those who are undergoing that will realize what a relief or what a balm on their pain this judgment is going to be if the Supreme Court, under 142 of the Constitution of India, under its inherent powers, and also under with the underlying principle of doing substantial justice in the real sense of the word, exercises this power and dissolves the marriage. Today, irretrievable breakdown of marriage, if made one of the grounds of divorce in a contested marriage, things would be easier, is what my suggestion is. Because for the litigants to cross from the lower court to the high court and high court to the Supreme Court takes a lifetime, takes 2 decades. We know how the pendency of the matters are here. So hence, the commission, the Law Commission of India had made suggestions, and they were unfortunately not made into a law or legislation, that irretrievable breakdown of marriage should be made one of the grounds of divorce in contested matter, even for the trial courts to decide whether they feel in their wisdom and with all the facts and circumstances, because that's a fact, a fact-checking court, to realize that if it is broken down, they are well within their rights. I have experienced as a lawyer, I must tell you this, that the courts are saying, we completely agree with you, Ms. Desmukh, that there is no substance in the marriage. We completely agree that there is separation, but we are bound by the fact that there is no ground of divorce as irretrievable breakdown of marriage. You have to call out a case of cruelty or desertion. So they agree off the record, but within the parameters of law, they cannot grant a decree. So I would like to take this opportunity to make one more suggestion to the legislation. Please introduce this as a ground of divorce in the legislation that we have, the Hindu Marriage Act, the Special Marriage Act, and the Parsi Marriage Act. It will really save a lot of heartburns and a lot of agony to thousands and lakhs of people who are languishing because they don't fulfill the so-called criteria.
Rekha Agarwal, just come in here. All right, the Supreme Court is saying, we understand your pain, so we are using our special powers under Article 142, and we will grant you this fast-track divorce if you fulfill these criteria. But does the Supreme Court then run the risk of becoming a family court? I mean, if you have to fix the problem where the problem comes first, which is a district court or a high court, instead of it having to go to the Supreme Court to have a marriage dissolved.
Absolutely. Yes. Yes, in fact, I would rather continue where Ms. Desmukh left off, and I fully agree with her views that Article 142 is the power which the Honorable Supreme Court has, that the family court, which is the district court, does not enjoy that power, nor does the High Court has. So if, first of all, if irretrievable breakdown of marriage is not added as a ground of divorce, on a ground on which any party can seek divorce under Section 13, of the Hindu Marriage Act or the other acts like the Parsi Marriage Act, etc. That means that we are still tied down, and any couple, any spouse who wants to take a divorce against his husband or wife first has to go back to the old stereotype grounds of divorce, that is cruelty, adultery, etc., etc. Then run your battle over there for a couple of years. Then by the time the marriage is actually irretrievably broken down. In fact, to be honest, as a divorce lawyer, I would say that when the number of years that it takes for any divorce litigation to get over, if it is not broken down initially, over the years it gets broken down. The irretrievable breakdown of marriage happens more because of passage of time, because of the number of years that any litigation takes place. Whatever scope that there was in the beginning of it getting salvaged it gets totally ruined because of the pendency of the litigation. After a couple of years, both sides have had enough of each other. They don't want to continue with that relationship at all. There's no sanctity left to that relationship. There's nothing sacred about it, except that they're two warring parties, as if it's a commercial dispute. So I think that first of all, though I fully, congratulate the Honorable Supreme Court, for this beautiful judgment, the constitutional bench judgment that has been passed, but it only, if I may so say, with utmost respect, that this point has already been, this power was already there with the Honorable Supreme Court, that there have been cases in the past also, and which Ms. Deshmukh just spoke about, where she has said that the Honorable Court was not willing to grant divorce on the ground of irretrievable breakdown, and said, no, Ms. Deshmukh, go back, And there have been cases where the Supreme Court has said, yes, this is a case where even though one party is saying that the marriage has not broken down, or that a party has got divorce, a party has not got, let me put it the other way, one party has been denied divorce by the family court. The High Court has also upheld that view that no divorce ground is made out. But ultimately, in the Supreme Court, the Supreme Court has said, okay, very well, we will not grant divorce, we will not hold the, continue with the marriage, on the ground of divorce, under the grounds laid down under the Hindu Marriage Act. But okay, fine, we will not make it out as a case of cruelty or desertion or cast any aspersion on either of the spouses, but pass our own judgment and say this is a case of irretrievable breakdown of marriage. So I think that, this is, not full justice, that we are just going halfway, and I think that the problem needs to be tackled at the bottom. Make irretrievable breakdown of marriage a ground on which either party can seek divorce, under Section 13 of the Hindu Marriage Act or whatever act is applicable, and then that power should be there in the family court itself. How many people can come to the Supreme Court? In this vast subcontinent that India is, it is not easy for any normal human being with limited means to engage a lawyer and come to the Supreme Court. So I think, and that 6 months period which the Supreme Court has again reiterated, that has already been upheld in the last 2-3 years in the case of Amardeep Kaur versus Harveen Kaur judgment, that in a case of mutual consent divorce, there is no need for any party to go through that cooling period of 6 months. So I think that today the Honorable Court has only clarified that yes, irretrievable breakdown of marriage can be a ground for granting divorce, but that power lies with the Supreme Court, and that if either of the parties goes rushing to the High Court or to the Supreme Court, exercising the writ jurisdiction which is there under 226 of the Constitution in the High Court and under Article 32 of the Supreme Court, that is not the correct forum. So, so there is no violation of your fundamental rights. If you're not able to get divorced or you're not able to get rid of your spouse, though a right to live a peaceful life and lead a life with dignity is your fundamental right, but you cannot get divorced on the ground of irretrievable breakdown by filing a writ petition. You will have to go to the Supreme Court under Article 142 only. That is what the Supreme Court has today clarified.
Okay, but Ms. Deshmukh, here's a quick question. We are calling it fast-track divorce because when you want to simplify things, you try and you try and use words which you think will easily communicate what the implication of a particular judgment is going to be. We are calling this, the Supreme Court fast-tracking divorce. But will it really fast-track divorces in this country given the pendency within the Supreme Court itself? And does the Supreme Court then run the risk of becoming a family court? Because things like divorce should actually be dealt by a family court, not the Supreme Court of India.
That's exactly what I think Rekha ji and me, we are talking about it. That kindly make an irretrievable breakdown of marriage as a ground for divorce in the legislation to be able to the parties to be able to opt for that option. Today, as she rightly stated, that you have to travel from the lower court to the High Court and High Court to the Supreme Court to reach that stage for the Supreme Court to exercise powers under 142. Are you aware of the amount of time, the money, the energy and the lifetime that people spend in doing that? Why can you not make it something which is more accessible at a trial court? Give them the powers under the legislation to make those suggestions, to kind of see the facts, what are the number of years they've been separated, what are the real issues, is it a real issue where the other party wants to do it, or is one of the parties abusing and misusing the law for a larger gain? Now, these are the things you must give more powers to the trial court. In my humble opinion, it is a trial court which is the basic court, which is a fact-finding court. They are the courts who should be empowered with this, because only then they will be able to consider all the facts in its reality and not give a standardized judgment that no case of cruelty is made out or no case of desertion is made out. Sorry, we cannot grant you the divorce. That is why it is the need of the hour, and I'm making this submission on your channel to the legislation and the legislators who are going to be doing this. Kindly bring this as a ground for divorce in the fault or the contested cases of divorce. It will make life easy for the litigants. If you have to meet the ends of justice, you have to make the life of the litigants easier, without there being any miscarriage of justice or without there being any kind of harm or otherwise being done to the other side. But do not keep people languished in marriages just because you do not feel that there is no cruelty or there is no so what if there. It's the need of the hour and a wake-up call. Not only the Supreme Court has laid the foundation, the legislation should lap it up in my opinion, and make that as a ground of divorce. And that will be the real justice that they would be delivering to the litigants and to the warring spouses who are caught in the crossfire.
I hope the powers that be are listening to you, Ms. Deshmukh and Ms. Agarwal today. Thank you very much. It was good to have you on the show. It was good to understand why the Supreme Court judgment is being called a landmark judgment, but what needs to be done further. It cannot stop here. There are things that need to be done further. You have to write it into legislation as well. That is how we can ensure that there is justice for everyone, not just with the people with the money and resources who can approach the Supreme Court, but even couples who come to a family court to apply for divorce. We'll leave it there for the moment, Ms. Deshmukh, Ms. Agarwal. Thank you very much for joining us here on Urban Debate. With that, it's a wrap from me. Samia is joining you up next with the news at 9. Do stay with us.